defender retention. And to that end, rather than rush through a bill fixing the technical issues, since we have a little bit of time before we need to deal with public defender reappointments, we thought we would start maybe an investigation and educational process and look at kind of what best practices might be, what other jurisdictions do. But to that end, one of the folks we've talked to during that process has been David Carroll and his colleagues at the Sixth Amendment Center. And he's going to give us a no more than 30-minute presentation today, because we've learned we need to do about what his organization does and what their perspective is on the best method of selecting public. And so I will turn it over to Mr. Carroll, who's presenting via Zoom.
Great. Thank you. Let me just share my screen. Great. Thank you, everyone. My name is David Carroll. I'm the Executive Director of the Sixth Amendment Center. The 6AC is a nonpartisan, nonprofit organization created to assist state, federal, and local policymakers understand the constitutional parameters that they must meet in providing indigent defense services. We do so by measuring jurisdictions against prevailing case law and national standards, and then assisting state and local governments to overcome any identified deficiencies. We are a right to counsel technical assistance provider for the United States Department of Justice. And over my 25+ year career, I've had the privilege of working in 49 of the 50 states and participating in sweeping reform work in states as diverse as Idaho, Utah, Michigan, Maine, and Louisiana. I want to accomplish 3 things today within a 30-minute time limit. One is to give a brief history of the right to counsel in America. I find how you talk to legislators about the right to counsel is very important to advancing needed reform. As a historian, let me just say, I also found Elisa's presentation fascinating on the 30-year-old statutory language. So shout out to her. We also want to teach you how 6AC evaluates indigent defense services, and then just raise some concerns about North Carolina's system based on our review of your current statutes. So let's get going. On March 18th, our country celebrated the 58th anniversary of Gideon versus Wainwright, guaranteeing the right to counsel in state courts. Although the Gideon decision is a very important decision, I find in my travels across the country that people have a profound misunderstanding of Gideon. Too often, I find people assume that no one in America had the right to a lawyer in criminal cases until 1963. And that means the right to counsel can too easily be painted as just another 1960s case decided by a decidedly liberal Warren court. So even though this quote on the screen is my favorite from Gideon, I draw your attention to the very next statement in Gideon. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to ensure fair trials before impartial tribunals in which every defendant stands equal before the law. Now, wait a minute. From the very beginning, is that true? The answer is yes. Courts in America have been appointing lawyers to the poor in criminal cases since before the United States was an independent country. You see, the adversarial system of justice is rooted in the very fabric of our nation. Because the European people that arrived on the shores of America were, in many instances, those who had been subject to religious persecution in European courts, the new people of the emerging nation were not content to adopt the justice system of their mother countries. Having experienced tyranny firsthand, the people of the new American colonies were suspicious of concentrated power in the hands of a few. An individual's right to liberty was self-evident, and therefore there needed to be a high threshold to allow government to take away that liberty that the Creator had endowed in each and every individual. Even before the American Revolution, American courts were appointing defense attorneys for the accused. Even before there were professional prosecutors, there were criminal defense attorneys for the accused. Now, do you not believe me? The very first right to counsel statute in what would become the United States comes from Rhode Island in 1660. Although this is in Old English, the gist is that anyone can accuse anyone of anything, as the statute states, out of envy or malice, and therefore the accused needs a lawyer to counter his accuser. I am always amazed that more than 330 years later, the US Supreme Court makes the same arguments in Gideon. So colonial courts are appointing attorneys early on to prevent the tyranny of big government from unduly taking away a person's liberty. Indeed, John Adams risked his reputation for these very ideals of liberty by defending in court the British soldiers involved in the Boston Massacre, stating that a defense lawyer ought to be the last thing a person should be without in a free country. With the introduction of defense lawyers in colonial America, criminal trials started to become, actual trials. Procedural rules started to be written down and codified. Evidence, including hearsay, could no longer be introduced without restraint, and allegations of criminalities were increasingly contested. It was the very birth of the adversarial process. In the immediate wake, just a sec, I've got to admit someone here to move. Okay. Something's going on with this. Sorry. There we go. Excuse me. In the immediate wake of our emerging country's call for self-determination and independence, the people of North Carolina moved quickly to ensure the right to counsel. Once Americans, so this is the federal code in, sorry, this is where I'm supposed to be, sorry. Every person accused of any misdemeanor whatsoever shall be entitled to counsel in all manners to make his defense. This is the 1777 Acts of the Assembly of the State of North Carolina. So in the immediate wake of our emerging country's call for self-determination and independence, the people of North Carolina moved quickly to ensure that right to counsel. And once Americans threw off the shackles of tyrannical monarchy in the Revolution, the Patriots were not about to create a new government that can infringe on the rights of others. All people, they were agreed, were free to express unpopular opinions or choose one's own religion or take up arms to protect one's home and family without fear of retaliation from the state. Right after the Constitution was ratified, our federal courts were required to affirmatively appoint attorneys to indigents charged with capital crimes as enshrined in the 1790s Judiciary Act on your screen. And remember that almost every federal crime was a capital charge back then. Think of things like horse thievery. So people were being affirmatively appointed counsel in the 1700s. Importantly, outside of the 13 original colonies, since most states were subsequently carved out of federal territories, the right to counsel in most states predates statehood. By the mid-1870s, Nevada becomes the first state in our country to require attorneys for the indigent accused in all case types, including misdemeanors, and the payment of attorneys for services rendered. Many other Western states followed suit. So by the time Gideon comes around, there were only 15 states that did not already have the right to counsel for poor people accused of serious crime. And in many of those 15 states, appointed counsel was the norm. It just hadn't been statutorily created. Really, it's only the states from Florida to Texas that come out of Spanish and French jurisprudence where the right to counsel is not fully taken hold by Gideon. So I said at the top that Gideon was important, not just for the reason most people think it is. You see, Gideon is not just a Sixth Amendment case, it is also a 14th Amendment case. That is, states are required by the 14th Amendment to ensure that Sixth Amendment case law is properly implemented. In post-Gideon, there is a lot of such case law. Here we'll slide into the second portion of my presentation and talk about how the Sixth Amendment Center evaluates indigent defense systems. In short, we measure indigent defense systems against prevailing US Supreme Court case law jurisprudence. That is, we want indigent defense systems to meet basic parameters of the 6th and 14th Amendments. So, for example, the death penalty is currently constitutional. Therefore, we note where the 6th Amendment requires more of states that choose to allow such punishments. So let's start quickly on what the 6th Amendment requires. First, Gideon established the right to counsel in felonies, but subsequent cases further define that right to counsel to apply to direct appeals, delinquencies, misdemeanors carrying suspended sentences, and appeals challenging a sentence from a guilty plea. SCOTUS has also delineated when in the process a lawyer must be provided by defining critical stages of the criminal process. There are really too many critical stages to go through on each and every one, but I do want to highlight that plea negotiations is one of those stages, which means a prosecutor may never engage an uncounseled defendant unless and until a court has determined that a waiver of counsel was made knowingly, intelligently, and voluntarily. Again, here are more critical stages. Basically, I want you to understand that the 14th Amendment requires states under the 6th Amendment is ever expanding and becoming more and more complicated. In my experience, one of the most difficult aspects of the 6th Amendment case law is that the right to counsel means more than just a warm body with a bar card standing next to every defendant in court. Rather, SCOTUS has continually said that the right to counsel is the right to effective counsel. So, as the court said in a very important case called the United States v. Cronic, of all the rights that an accused person has, the right to be represented by counsel is by far the most pervasive, for it affects his ability to assert any other rights he may have. Further on, stating, the right to effective assistance of counsel is thus the right of the accused to require the prosecution's case to survive the crucible of meaningful adversarial testing. It is the process, if the process loses that characterization as a confrontation between adversaries, the constitutional guarantee is violated. I don't want to get too far down in the weeds with the time limit on the case law regarding ineffective assistance of counsel, but you do need to know that Cronic delineates what is required of states in creating indigent defense systems. So Cronic says, there are certain circumstances where the structure is so deficient that any lawyer would fail to provide effective assistance of counsel. The court then highlights one case to show what they mean. That case is the case of the so-called Scottsboro boys who were falsely accused of rape in Alabama. In that case, the judge handpicked the attorneys who did not have sufficient time to adequately defend the accused, and the attorneys were not qualified to handle the complexity of the issues in the case. In short, the judge chose a real estate lawyer the morning of trial to represent all of the defendants. In Cronic's sister case, Strickland v. Washington, SCOTUS says, when governments structure indigent defense systems in ways that interfere with the representation, the system itself should be considered presumptively ineffective. Note that I could spend most of the day going through a great deal of Cronic and Powell, but the ABA has basically boiled all this down to 10 simple principles. In the words of the ABA, the 10 principles represent fundamental criteria necessary to design a system that provides effective, efficient, high quality, ethical, conflict-free legal representation for criminal defendants who are unable to afford an attorney. The 10 principles include 4 main parameters of the Cronic analysis, including early appointment of counsel, qualifications, training, and resources of attorneys, independence of the defense function, and sufficiency of time needed to perform the basic functions. For example, Principle 3 talks about early appointment of counsel. Indeed, commentary states that counsel should be appointed within 24 hours. In 2018, we published a report on Mississippi. In that state, all felonies must be filed by indictment, not just in information. We found that formal appointments only occur after arraignment on the indictment. Now just think what that means in rural Mississippi, when a grand jury may only sit once a year. Defendants can sit in jail for a year without counsel, and we found many of them. Or, as SCOTUS says in Powell again, impeding counsel's time is not to proceed promptly in the calm spirit of regulated justice, but to go forward with the haste of a mob. Now, before I explain our reading of certain North Carolina statutes, I want to talk to you about one other core foundational standard required of effective indigent defense systems. ABA Principle 1 is about independence of the defense function. Again, independence is not critical because the ABA says it is important, but rather because SCOTUS has said so. It is just that the ABA is trying to make these principles more easily understood by policymakers who may not be lawyers. So, for example, there are a number of cases in which SCOTUS comments on the need for independence of the defense function. Ferry v. Ackerman states, the independence of appointed counsel to act as an adversary is an indispensable element of effective representation. Polk County v. Dodson says, government has a constitutional obligation to respect the professional independence of the public defenders who it engages. Continuing on, a defense lawyer best serves the public not by acting on the state's behalf or in concert with it, but rather by advancing the undivided interests of the client. And thus, a public defender is not amenable to administrative direction in the same sense of other state employees. Even Strickland says, independence of defense counsel is constitutionally protected. And that's the segue into the third part of this presentation, how the Sixth Amendment Center reads North Carolina statutes. Now, obviously, I have a caveat here. We have not formally evaluated your state. When we do an evaluation, we usually have an in-state body choose a sample of counties for us to go to conduct court observations and interviews with criminal justice stakeholders and policymakers, analyze available data, etc. Often it is the case that our initial issues raised on review of statutes turn out not to be the problems that we thought it was. So we're not saying this is something that really is a problem, but we strongly suspect that it is. So with that caveat, we raised two main concerns with statutes that appear to cause independent concerns. The first is the statute requirement that brings undue political and judicial interference into the decisions about where and when to open public defender offices. North Carolina statutes do not leave the decision up to the North Carolina Indigent Defense Services Commission or the office, as is the norm among states with statewide indigent defense system. Here I'm going to pause and actually do a shout out to IDS. The Sixth Amendment Center used a lot of your research, especially on the cost efficiency of public defender offices over private attorneys in many other states. And they're able to use your research to expand public defenders into places where they feel it is most effective and efficient for their state. But North Carolina seems to not have the freedom that most states do on this issue. As you know, instead, NCIDS must not only consult with the local bar and the local judiciary, two parties that may be happy with the status quo, but then must also get the statute amended to include a new district in the public defender office part of the statute. That is a very complicated, we would argue, political infringement on the indigent defense system. The same statute also allows the judiciary to appoint the public defender of any office that is open. Again, we consider this to be judicial interference. Judges should hold no greater influence over one side of the adversarial process as the other. Anytime that political or judicial interference comes into play, the constitutionality of the indigent defense system comes into question. For example, SCOTUS is particularly concerned about undue judicial interference over the indigent defense system. Again, in Powell, the case of the Scottsboro boys, SCOTUS states, how can a judge whose function is purely judicial effectively discharge the, I'm sorry, I'm getting caught up because my picture's in front of this. How can, I'll let you read it, but basically it's saying judges cannot possibly know everything about an indigent defense system and whether it's working effectively because they can't ever get into a case file or interview clients. Judges should have no role in the indigent defense system. And this has been in dicta with the Supreme Court as far back as 1932. In my 25 years of traveling across this country, I do want to say more often, it is more often the case than not, that a judge does not need to overtly say in his courtroom, do not file any motions here because I want to keep the dockets moving. Indeed, it's the public defense attorneys themselves that internalize a conflict of interest in which they seek to balance what is in the stated interests of the defendant and what they need to do to please the judge to get their next appointment or their next contract to keep food on their family's table. So a lack of independence of the defense function creates a myriad of conflicts of interest, especially when undue judicial involvement occurs. The local bar may not want a public defender office because it has figured out how to please the judge to get the next appointment. The judiciary may be happy because it does not see how lawyers may be compromising the stated interest of the defendants to do what they think is necessary to stay in the judge's good favor. On top of that, it allows for those two forces for this to maintain the status quo, to lobby the legislature not to amend the statute to open any potential offices that NCIDS believes would benefit the state. So with that, I apologize for some of the sticking slides and some of the technical issues, but I think you've gotten the gist. And I'll close just putting it back on this last quote from Gideon that says, the right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. Thank you very much. I think I made it under the half-hour deadline, but I'm happy to take any questions if people have any. Thank you.
Commissioners have any questions? Okay. Seeing none, I appreciate you joining us today, Mr. Carroll. Do you have any party?
No, I appreciate that. Thank you very much. And if it's all right, we'll share your slides with the commissioners after the meeting.
Great. Absolutely. Thank you.
Move into commission business, and I'm going to recognize Dorothy Harrison Mitchell to talk about the diversity policy.
Hello, everyone. I appreciate this opportunity to be able to speak on our IDS policy on diversity. As you see here, I have it as diversity, inclusion, and equity. And what I would like to do first, that you all the commissioners have received a copy of the proposed diversity, inclusion, and equity statement and plan that the committee has created. And so hopefully you would have already reviewed that. But I would like to touch on a few things and kind of give a little bit of information about the different terms and why we have the terminology that we have in the statement and the plan, and then the steps moving forward. Okay. So I will start with, what is diversity? First, I want to say that I know that when we hear that word, we all like to think that we know what diversity means. And we immediately jump to what we believe that is. And so even if it is based on, if it is the basic meaning of just being different, okay? But it actually means a little bit more than that. And so you see here, I have an Oxford Dictionary definitions on the state of being diverse, variety, the practice of or quality of including or involving people from a range of different social and ethnic backgrounds and of different genders, sexual orientations, et cetera, et cetera. It also refers to all the similarities and differences that define us as human beings. It's a wide variety of differences and similarities. They're often referred to as dimensions among people. And I will let you all know that in working with this committee, and just the times that we are in, and I've done a lot of research in this area, and it was very enlightening to me, that, like I said, the everyday terminology, what we see as everyday terminology is not necessarily what we think it is. And so you'll see what I'm talking about a little bit more. I know this looks like a lot, but I'll break it down. So as far as diversity in the workplace and in organizations, we often look to 4 different types of diversity. And this is an area that I was enlightened, because I never thought about the different types of diversity. When you think of diversity, you just think diversity. So you have internal diversity, external diversity, organizational diversity, and worldview diversity. And as you see there, internal diversity are those characteristics that a person is born with or born into. So those are things that people don't choose for themselves, and it's impossible to change those things. Examples are race, ethnicity, age, nationality, but that list is there, you can see that. And then we go to external diversity. Those are characteristics that a person is not born with or born into. And those are things that can be greatly influenced by other people and their surroundings. And there are ultimately aspects that a person can change, okay? And oftentimes those things, that diversity may change over time, okay? Those examples of that is education, appearance, so on and so forth. You see the list there. I'm trying to stay within our time. Then organizational diversity, also called functional diversity. No matter what position or pay you may have, whatever work you're in or whatever you work in with or who, it solidifies your belonging in an organization. You see here, this relates to the differences between people that are assigned to them by an organization. These characteristics, those are characteristics that are within a workplace that distinguish one employee from another. And then of course, for like an organization like we have, one person from another, one commissioner from another, one leader from another, okay? There are different subsets under organizational diversity, and those include job function, place of work, management status, employment status, pay type, seniority, union affiliation. It could be a private or nonprofit, public sector or governmental organization. No matter what, you are part of an organized group in some sort of some way or sort of fashion. Okay. Then we move to worldview diversity. There are a number of factors that come together to form a worldview, including characteristics from all other types of diversity. So it encompasses the other 3 types, and we all have a worldview that we align with. And I think we all can agree on that. We know that, right? It changes over time as well, because it's based on the different experiences we may have and the self-reflection that we may go through over time. And I know some of us are young, some of us are more seasoned, and so probably the more seasoned people can really relate to that you probably change your worldview a lot of times over time, right? So we see, like I said, we see things differently based on those experiences and self-reflection. Those examples would include political beliefs, moral compass, outlook on life, philosophy, right? This is just another chart that says all of what I just said in the 4 different types of diversity, just in a different format. And y'all know I'm a professor, so I like to present it in different formats because we have different types to learn. So that's there. Then we have, what is equity and why not equality? Because I'm sure some of you probably read our statement in our plan and said, well, why did they choose the word equity as opposed to equality? And so I want to talk about why we did that and why we chose that word. So equity here is justice according to natural law or right, the state quality or ideal of being just, impartial, or fair, and is synonymous with fairness or justice. So here's the classroom side of me too. Can somebody volunteer and tell me which one of these pictures, of the 2 pictures that are on here, which one denotes equality and which one denotes equity? Or should I say, which one is the, let's say, equality picture? Anybody? I can't see everybody on the screen, y'all. So if somebody's volunteering, I don't want to do you, put y'all back in law school or in class and just call on somebody,
Margaret volunteered.
okay? Margaret,
Left is equality. They all have the same stool. Right is equity.
absolutely. Do you want to go into a little bit more on what's different between the equality and equity?
So equality, they all have the exact same stool, but they weren't all born with the same height. So it has a disparate impact, and equity has more to do with the impact of how things are processed or put in place.
Margaret, and if we were in class, I would give you a high five or throw you some candy or something. All right, so you are absolutely correct. Equality is on the left, equity is on the right. Equality, like Margaret said, that all the persons are given the same resources, but because they have different heights, they're not able to all see over the fence. And then the right side is equity. Each person is given resources they need in order to see the same or to have an equitable opportunity. And so that is why we chose the word equity as opposed to equality. And so what do we have now? As you see here, that picture on the bottom is what we have now, and I'm not just saying us as IDS, just in general, in most organizations or in the world, that's what you usually see. And then the picture on the right is just another picture to show, because it's, some people want to see this, what if I'm reaching for something, okay? So it's just another example of equality versus equity. All right, now let's look at what is inclusion. Now inclusion is according to Oxford Dictionary, the action or state of including or being included within a group or structure, the practice or policy of providing equal access to opportunities and resources for people who might otherwise be excluded or marginalized, such as those who have physical or mental disabilities and members of minority groups. It's a sense of belonging. It's feeling respected, valued, and seen for who we are as individuals. And it's more than diversity, and it's more than numerical representation. And when you have inclusion, there's a level of supportive energy and commitment from your leaders and your colleagues and others so that we individually and collectively can do our best work, okay? So inclusion involves that authentic and empowered participation and a true sense of belonging. That is what we want to strive for, right? So here, why diversity? Why equity? Why inclusion? Why is all of that so important? Because all of these phrases or words that you see here, these are things that will come about if we have these things. We want to achieve or have as much diversity and equity and inclusion on all fronts for varied perspectives, better problem solving, better job pool, et cetera, et cetera. You all see those there, which will have people think more creatively and they're more likely to be happy. And we want some happiness going on, right? And you definitely want happiness in the workplace. And for our purposes, you want people to feel happy when they come to the training sessions that we provide and all the CLEs and presentations and different things, because they are seeing people who look like them and may think like them or may think differently than them, but they are more open to diverse mindsets and things than what they've seen in the past. And so having a workplace or organization, I found this is a quote that I found. Having a workplace or organization that has zero tolerance for certain negative behavior and discrimination and is more inviting to those groups that have been discriminated against is a conscious decision that makes the entire organization a better place and can ultimately make the community better. Now, what do we want to see? All right, we want to have what the goal is for us to strive, what we strive to achieve is what you see here. And it, hopefully you're seeing it is these things interwoven together, okay? So you have, we want our plan and our goals to be interwoven into our policies and practices as you see here. And it should be intentional and integrated and institutionalized. We have so many negative things that are institutionalized. Let's start working on some positive things being institutionalized, right? It should be in, and once those things occur on that left side, then hopefully it creates awareness, a better attitude, and greater action that will take place. And then lastly, I'm zooming. I'm getting the looks from Mary. She's proud of me. I'm working through this really quickly. All right. So, as I stated before, our committee has worked on it. So we formed a diversity not subcommittee, a diversity committee of the commission. And so the committee members are Judge Lisa Menifee, Art Biller, Jan Pritchett, Kate Finhagen. We had Sarah Olson, who did a lot of the heavy lifting. I appreciate you so much, Sarah Olson. And then Mary Pollard and then Whitney Fairbanks assisted us as well. And so we all came together and we created the statement that you all received and the plan. You all saw the statement before, and I think that we got some approval before of the prior statement, but the new one that you received in your packet that also has the plan attached to it has some edits in it. And so what happened is we went back, our committee, we realized that we were reading more words into our statement when we started to create our plans. We were reading more words into our statement in our plan than what was actually in it. So we had left out the word equity. And so we went back in and we included equity in all the places that made sense for us to have equity. So now the statement includes diversity, equity, and inclusion. And so those are the edits as far as the actual statement. And so what we envision, as you see in the plan, is for this statement and this plan to be posted on all our media outlets and on our website, go out in all our materials that we send out. And then the plan includes all these different goals. It is, make sure I'm saying the right number, 6 goals. And all those different goals have various numbers of strategies under each one that we have decided and come together as a committee that will be really useful, really good for us moving forward and for us to really do a good job of integrating all of these different things and institutionalizing this statement and plan into what we do in our policies. So that first step is the creation of the statement and the plan. We've done that as a committee. And so I want to publicly thank the committee members for doing that. We worked really, really hard. This was a labor of love in a lot of ways, and we're really proud of the statement and the plan that we've submitted here to you all, presented to you all. Now we're at the point of asking that the full commission adopts this statement and plan. And so at the appropriate time, I'd ask for a motion where it comes out of committee, so we need just a second, and then a formal vote so that we can officially adopt this plan and this statement and then the plan. If it is adopted, hopefully it will be, we will then move to the next step. And our IDS leadership, under the great leadership of Ms. Pollard, will create a process to facilitate the plan and collect data. And I should say we'll continue working on that process because they've already begun that process. And so they're going to continue working on that so that those goals and those strategies will actually be implemented. And it's not just something that we have on paper. And then from there, IDS leadership and the commission will review data, because as you see in some of the goals, there's data that we're going to collect, information that we're going to collect. And we want to, because we don't just want to have this, like I said, we want to make sure that we actually are doing what we have in our plan. And so we will review that data based on an established process and timing that our leadership will outline for us. And then from there, our IDS leadership and commission will review and update the statement and plan as needed. And so that is what I have. Like I said, I guess this will be, unless there are any questions or concerns, I would ask for a call of vote.
I think that because this comes out of committee, a second's not needed. So I would open it up for any questions or comments prior to us taking a vote on the adoption. Can we go ahead and unshare the screen?
Oh, I'm sorry.
That's okay.
So sorry.
So any questions or comments that anyone would like to make, if you would raise your hand or whatever on the Zoom. If there are no questions or comments, then I would call it to a vote. If you are in favor of adopting the statement as outlined by Ms. Hairston Mitchell, please raise your hand or vote yes in that box. And if you oppose, vote no. And I have a yes here and a yes here and a yes here. So I think that it is unanimous. Carries, so we will note in the minutes that has been adopted. Thank you for
Hey,
your work.
Darren, I do have a question. I applaud the subcommittee's work and the presentation. I've already asked Dorothy for a copy of it. I'd like to take pieces of it to show to my firm. Is there an economic component to this? When I say that, are we going to devote certain resources to making sure that diversity and equity are part of IDS's fabric?
Larry?
Well, the plan as drafted, we've not really done a fiscal note or sought to quantify what it would cost. We did have some discussions during the subcommittee meetings, and I think everything that is outlined in here is attainable, or we will make it attainable with our current resources. I could see down the road where we would want to devote some resources, and we'll quantify those and try to find them and get them. Particularly staff time.
Absolutely.
So that's, I don't know if that answers your question, but that's sort of where we are with it.
It does answer my question. I would recommend, not today, but at some point, the commission eyeball an opportunity to make this a line item in our budget going forward.
I appreciate that, Mr. Cromwell. I totally agree with you, and I appreciate you bringing that up. And if I could say also that I am so proud, and I know I said it before, but I just want to say it again, that this commission decided that this was an important thing to do. And it feels really, really good for us to be one of the leaders in this, and that we got on this immediately and we saw the need, and we're going to make sure that this becomes a part of our policies and our procedures.
Okay,
And Commissioner Rubain has her hand raised.
Ms. Rubain.
Oh, I'm sorry. I think I must have hit the button. I don't have any questions. Thank you.
Hey, thank you. Okay, yes, ma'am.
I just wanted to say, thank you, Dorothy, and I wasn't I wasn't looking at you to hurry up. I was looking at you because I was like, wow, I wish she would have been my law professor. Except I think you were only about 8 years old, so that wouldn't have worked. But thank you for that presentation.
You're welcome.
And this was really a tremendous amount of work for you and for the subcommittee and for Sarah Olson. And I'm glad you gave her a shout out. She's worked really hard.
She's been phenomenal.
Yeah, she really is. So thank you. That's all I have to say.
Is there any more commission business before we go into executive session that you guys know of? So I will entertain a motion, Judge Crosswhite, to go into a closed session of the commission under 143-318.11 for 2 reasons. Subsection 2, to prevent the premature disclosure of an honorary degree or award. And for 3, to consult with our attorney who is employed by the Indigent Defense Commission. Do you make that motion?
I do.
All right. And Ms. Harrison Mitchell, do you second that motion?
I do.
We appreciate that. All in favor of going into executive session for those 2 purposes, please say aye or hit yes on your button, please.
I
Aye. And I'm going to assume that that motion carries based on what I see. And we will now go into executive session. And do we know how to do that with YouTube?
Let's take a several minute